Well, my clients basically are members of the Gujjar Bakerwal community in Jammu and Kashmir. They're members of a scheduled tribe. They constitute 73.25% of the total scheduled tribe population of Jammu and Kashmir.
73.25%.
73.25%. But of course, we strongly support the amendments for the reason that the provisions in the Constitution pertaining to scheduled tribes, 330, etc., were never applied.
But Mr. Jethmalani, your knowledge is theoretical unless you can state with certainty before us that you have driven around in Ladakh. Have you been?
I've been to Ladakh. I have been to Ladakh. But Manoj, many years ago, many years ago, Manoj, in the days when houseboats used to flourish, in those days, Manoj. And they've come back now.
Houseboats are not there in Ladakh. I have not seen a houseboat in Ladakh.
No, houseboat in Srinagar and then from there on. Why don't you go there? I'm told a lot of people go there now. It's go there and take a look for yourself. Empirical evidence will stare you in the face. The Himalayan car rally, which used to take place then in the former days, has now been revived. My daughter's scheduled to go soon to Leh and Ladakh in that Himalayan car rally. So they're taking a sports car themselves and traveling up. She and her friends.
Justice Variava used to participate.
Yes, your fortune is right, Justice Variava. All affirmations from the reaffirmations from the other side about the congenial climate that now takes place in Jammu and Kashmir. But my clients are restricting themselves to the challenge to 373 and the proviso thereto, as also to the amendment to 367 brought about by CO 272. I'm not going into the question of 356 and the territorial reorganization. That's beyond tribal folk. And 356 really deals with the satisfaction of the president and the governor's report and so on. Matters which are best dealt with by the government. So I'm not going into that. I'm going to these two questions only.
So you're going to go into 373?
370, the proviso.
And
367 amendment, which replaced by CO 272, dated 5th August 2019, which substituted the word constituent assembly with the word legislative assembly. Incidentally, I might just mention that my clients are the beneficiaries subsequent to 5th August 2019.
Actually, you very helpfully identified the 4 key areas in the case,
yes,
which the case turns. 1, 370 itself, and the proviso to 370 bracket 3. 2, the use of the amending power under 367. 3, the reorganization, and 4, 356.
Those are really the 4 issues which arise at this.
4 areas, I would say, for the issues which arise from.
So, with regard to the latter 2, I'm adopting the arguments of the state, of the government.
All right. How would you formulate yours so that then we
Yes.
can...
Now, I submitted written submissions
Yes, we have got that.
2 days ago. Yes, sir. But briefly on the question of sovereignty, where does sovereignty lie? Because it then dovetails into the question, which are the subject matter of the two issues I am going to deal with. Just a brief overview about the sovereignty question. And I divide it, sovereignty can be looked at in various different ways. There are many divisions, external, internal, political, legal. But I'm going to just talk about the political and legal sovereignty very briefly, these two issues. And as far as political sovereignty is concerned, there is no doubt that the other side has not even seriously challenged its political sovereignty rests with the Union. And the clearest indication of that is the preamble.
Union.
Political sovereignty rests with the Union. Qua the state. And a simple look at the preamble, my lord, would indicate that. The preamble of the two, the Union and the federating unit of the state of Jammu and Kashmir, would reveal that. A point noted by Justice Nariman in the State Bank of India case. We'll kindly have a look first at our preamble very quickly. We, the people of India, having solemnly resolved to constitute India into a sovereign, the word sovereign is key, socialist, secular, democratic republic. Now, in contrast, the Constitution of Jammu and Kashmir has the following preamble. We, the people of state of Jammu and Kashmir, having solemnly resolved in pursuance of accession of this state to India, which took place on 26th October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof. So now the preamble itself makes no mention of sovereignty. In fact, the preamble is dealt with further defining the existing relationship of the state with the Union as an integral part thereof. So it's an acknowledgement of the Union's sovereignty over the state. This is political sovereignty. The Constitution was geared towards defining the relationship of Jammu and Kashmir for the Union as an integral part of the Union.
Yes.
And first and foremost, the permanent residents of the state of Jammu and Kashmir are citizens of India. Although Mr. Lord may sometimes behave that he's not, but in fact he is. Now I come to the question of legislative. Sorry. Legislative sovereignty is divided between the Union and the state. And on a look at Article 370, which is the governing article of the relationship between the Union and the state. Matters in the concurrent and Union list acceded to by the then Maharaja are within the realm of the center, the Union. And broadly speaking, well, the other parts of the Constitution are within the jurisdiction of the state. And
But therefore, the sequitur of your argument would be that matters which do not form part of the instrument of accession in relation to which the union was given exclusive control,
Yes.
the 4 matters,
yes,
the legislative sovereignty would therefore continue to vest with the Jammu and
continue to
Kashmir
vest,
Legislative Assembly.
subject to the power of the president to apply the provisions of the Constitution under B 1 and 2, but with the concurrence or the consultation of the state. So, any provision, theoretically speaking, if those qualifications arise, if that concurrence or that consultation takes place, then the entire Constitution can be applied to the state of Jammu and Kashmir under 371. 373 is distinct from 371 because it's at a one-stroke abrogation of the entire Article 370.
Therefore, Mr. Jethmalani, you therefore also necessarily accept that there is a concept, sovereignty has 2 connotations.
Yes.
One, external sovereignty,
Yes,
which undoubtedly vests completely with the Union of India. Internal sovereignty, which is then distributed between the Union and the states.
yes, yes. That's a patent look at that. Nobody can deny that. But the Constitution envisages that from time to time, further and further, and that's been the, as has been pointed out repeatedly during the course of these arguments, that with the passage of time from 1950 onwards, more and more provisions of the Constitution have been made applicable. And some of them are those which were not originally applicable to the legislative or within the legislative jurisdiction of the center. But ultimate legal sovereignty rests with the union. And though that is Article 373. Article 370, sub-article 3 is indicative of the fact that ultimate legal sovereignty, in the sense that you can get rid of the tunnel altogether that connects the union with the state legally and constitutionally. Ultimate legal sovereignty rests with the Union of India. And 373 is key, is one of the key issues in this entire discussion. It's in all these arguments, 373, and the reading of the proviso, the effect of the proviso. That establishes most of the issues that arise in this case, at least it sets a platform whereby the others can be. Absent that, there would be nothing else, which is why the other side is at pains to point out that after the Constituent Assembly dissolved or became extinct, 373 has no application. In other words, the substantive part of 373 is now swallowed by the proviso. The absence of the Constituent Assembly and the power of recommendation which was vested in it has now disappeared. That's their case. Now, on that proviso, I'll have something to say. But this is the sovereignty issue. Now, there is also Article 147, which is some indication of legal sovereignty of the state of Jammu and Kashmir. That's the amending part. That is an acknowledgement. The third part of C clause C of 147 is an acknowledgement by the state of Jammu and Kashmir that they cannot touch the Constitution of India as applicable to the state of Jammu and Kashmir. Some of the issue of Article 373 and the proviso thereto, it actually dovetails into three questions which I'll just frame, which are at the heart of the controversy here. The first is Article 370 temporary or permanent? Did the extinction of the Constituent Assembly of Jammu and Kashmir referred to in the proviso to that article render entire Article 373 oshos? And third, was the amendment by CO 272, dated 5th August 2019, to Section 377, to Section 367. Sorry, but to Article 367. Article 367. By the addition of clause 4D, well, that article which made Constituent Assembly read as Legislative Assembly, was that constitutionally valid? Number
Just since we have 55 minutes now to lunch, we'll give you time till 12:20. Mr. Guru, 12:35. Then we will hear the interveners for 2 to 5 minutes, and then we'll give Mr. Banerjee the interveners between 12:35 and 12:50, and Mr. Banerjee 12:50 to 1. That's the way we'll do it.
But because I have to read some extremely important constitutional orders, see, just
Please
very briefly.
give us the page
Yes,
reference
but I
and
just
the
want to read
para.
the portion that I'll tell your lordship what my argument. I'll come to it in a minute.
Well, let's get to the argument.
Yes,
I
yes.
think we are losing time
Let's
with the
not
15
waste time
minutes
on
available.
time management. I agree.
Yes.
Now, my lord, as far as the temporary and permanent part is concerned, two issues have already been discussed. One is Article 370 is a provision that is a part of Chapter 21 of the Constitution of India, which deals with temporary provisions.
Yes.
Lordships have already noted that. Second is the title of the article, which describes its provisions as temporary provisions with respect to the state of Jammu and Kashmir. And my lord, third is the effect of the proviso requiring the prior necessary recommendation of the Constituent Assembly of Jammu and Kashmir before the president can act under 373(1).
So your contention is that the Constituent Assembly of Jammu and Kashmir was necessarily limited in point of time and purpose.
But I'll tell
Time, the framing of the constitution for the state, purpose, once that purpose was over, it had to come to an end. That's your submission.
and one of the proviso, and not just one judgment, which I'll just give your lordship the citation, that it is a principle of construction that unless clearly indicated, a proviso would not take away substantive rights or powers conferred by a section or a subsection. Now that's Madhu Gopal's case, and the citation is in my written submissions, paragraph 7.
Just give us the volume, PDF
Yes.
page and para.
But I've annexed it to my note. But if your lordship wants it in the PDF,
Just give it to us here. We have taken it.
I don't think
you
it's
don't have to flip.
it's not in the PDF. I'm not.
It's not.
It's not in your lordship.
Case law PDF. Case law PDF.
It's a very short judgment, literally 2.5 pages.
Anyway, GP Singh's interpretation of statutes, a whole section on how to construe a proviso.
Yes.
Sometimes it's explanatory, sometimes it's an exception, it's clarificatory.
But the principle seems to be that unless clearly indicated, it would not take away the substantive rights conferred by the main section.
All.
Now, just a look at 373, and then I take you to my submissions on this most important point.
Yes.
Now, the Constitution and its provisions have to be looked at the perspective of people drafting it in 1950. Well, in 1950, when they did not know who the ultimate constituent power would be in Jammu and Kashmir. Essentially, what was 370? 373, which talked about the article ceasing to be operative altogether, because it was the terminus of the entire article. That article required the constituent power on behalf of the Union, acting on the one hand, which is the President of India, qua 370 and Article 3, qua Jammu and Kashmir through Article 370, he was acting as a constituent power. And on the other hand, the constituent power for the state of Jammu and Kashmir at that time was the Constituent Assembly. All documents from 1948 to 1950, all constitutional documents indicate that a Constituent Assembly, for the purpose of framing a constitution, was necessary, and that was the way forward, which is why Article 373 referred to the Constituent Assembly. But that didn't mean that once the Constituent Assembly completed its task, which was the task of framing the Constitution, that Article 373 would have no meaning, it would be ocious. Now, on the contrary, the COs issued from 1948 onwards, and now this is important, indicate two things. I'll just take a lot very quickly through those COs now.
What do they indicate?
Yes. First, they indicate expressly that the Constituent Assembly and the Legislative Assembly, insofar as it applies to Constitution of India, are synonymous. In other words,
Come again. The Constituent Assembly
and the Legislative Assembly are synonymous. I'll point out that expressly.
Where do you get that from?
From the various orders right up to 58. That they are to be read as the same. They are to be read as the same. Now, your Lordship may kindly see straight away the first one, which is CO10. CO10? What's the date? CO10, 26 January 1950. Now, this was the same time as the Constitution. Adoption of our Constitution. 26 January 1950. This CO CO.
So what part of CO10 are you relying upon?
Second schedule. Where's it? The PDF page?
Just give us the volume and page,
Yes.
so that we have it at one place.
Documents volume 3, PDF page 7.
What does the second schedule do?
Now, the second schedule says Articles 54 and 55 shall apply, subject to the modifications. Now, Articles 54 and 55 refers to the elections for the President of India.
What's the PDF page number?
Yes.
Page 7.
Page 7.
Seven. In documents volume 3.
Volume 3?
Yes.
Yes.
This is in column 3 of the second schedule. That the reference to the elected members of the legislative assemblies of the state and to each such, has the Lordship got it, man?
Yes.
And to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state.
Because there was no legislative assembly at all.
No legislative assembly. I'll show you. There was no, absolutely right. There was no legislative assembly at that time. But even when there was, so look, that's the whole point. The point is, it was deemed to be a legislative assembly for the purpose of our constitution. Why was this necessary? In 55, they were trying to get members of the Legislative Assembly of Jammu and Kashmir.
All right, which is the next point? Which
Yes.
is the next article?
The next order. So by a deeming fiction, the Legislative Assembly members were the
Give us
Constitution.
the next one, because we are now
Yes.
5 minutes short of the.
Yes. Then one not. The next one is CO 39. That's at PDF page 10. See, volume 3 again, PDF page 10.
CO 39.
PDF page 10.
Yes.
Reference to the elected members of the legislative assemblies of the states and to each such elected member shall be deemed to include respectively a reference to the members of the constituent assembly of the state and to each such members. Now, in CO 48, which is the next one, I'm running through it now, and this was in 1954. The date of CO 48 is 15th May 1954. Now, in this CO,
That's you, you're saying?
so that's about volume 3, PDF page 13. And I'm reading at page 18.
That is CO number?
48, dated 15th May 1954.
Right, that's a 54.
Yes.
That's page 18. All right.
Now, in this CO, for the first time, previously it was done by COs. But for the first time, Article 367 was amended
Right.
as applicable to J and K.
How is it relevant for your argument that Constituent Assembly means Legislative Assembly?
Because that's what the Union of India has done. They have amended 367.
It's clause D.
Yes, yes. That's CO 272, which is under challenge. The same procedure was undertaken in 1954. For the first time this was done.
This was also pointed out to us by, I think, the learned solicitor.
In fact, that's in his list of days. It's the first exercise of 367 power.
But it was even, yes. But even earlier, they were synonymous. The Legislative Assembly and the Constituent Assembly. It emanated from 1948.
This 14th of May 1954.
Yes, no, 15th of May 1950.
Right. When there's no Legislative Assembly in Jammu and Kashmir.
No, it's not. But now an amendment is made that they will be the same. Even when there's no Legislative Assembly. And now we are not talking about for the purpose of a presidential election. This is now for every purpose.
All right, which is the next CO?
Then, my Lord, Your Lordship, I just see a provision in the Constitution of Jammu and Kashmir, 85(2), 85 subsection 2. This is at PDF page 56, volume 2.
PDF page?
PDF page 56. Until rules are made under subsection 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the constituent assembly while discharging the functions of the legislative assembly shall have effect in relation to each house of the legislature. There was only one, subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be. My Lord, substantively and in matters of procedure, the Constituent Assembly and the Legislative Assembly. In fact, what emanates from all this is that the Constitution.
But Mr. Jethmalani,
Yes.
the fact still remains that after the Constitution of Jammu and Kashmir was framed
Yes,
on 26th of January 1957,
yes,
Article 367 4D was again amended.
Yeah.
So delete clause D.
yes. But Malord, that
So that equivalence between the Constituent Assembly and the Legislative Assembly ceases the moment the Constitution of
you're-
Jammu and Kashmir is framed.
Lordship is absolutely right. Now I'm coming to that last one in 58. That's the last piece. But my lord, what happened is,
That you will find at your volume 3, page 25.
yes, your lordship is at page 25. But that's the point is, all this shows that the Legislative Assembly, and why was this deleted? This was deleted because after the dissolution or the extinction of the Constituent Assembly, the constituent power in Jammu and Kashmir was now the Legislative Assembly. The power of amendment, in Article 368, it's in virtue of its being a constituent power that Parliament can amend. This is also recognized by at least 3 judgments in Indira Gandhi's, Nehru's case with Raj Narayan. I go back to the beginning of what I said, right at the outset, that the idea was that 373 being the final step, after which Article 370 altogether ceased to exist.
The only distinction is that a legislature which exercises the power of amendment
Yes,
is not a constituent assembly. It's exercising a constituent power.
I agree it is. I agree it is. But otherwise, the alternative interpretation would be that abrogation ceases to exist. You can never abrogate Article 370. That would be the alternative conclusion. We have to see why Parliament amended to Article 370 through 367 in the manner which it did. That's the whole challenge to 272. That is the whole challenge. And it did so because not only was it synonymous for they wore 2 hats. The Constituent Assembly wore 2 hats. The same people, the 75 people who constituted the Constituent Assembly in 1951 when it was convened, were the same people who were also members of the Legislative Assembly.
Argument of the learned solicitor is that independent of the amendment of Article 367,
Yes.
370 bracket 3 and the exercise of that power still stands.
Of course it
And
stands.
it still survives.
Because I'll tell you, Lordship, why.
Have to go as far as, according to him, he has not pitched it. Though he said, look, 367 has also been used in the past.
Yes, yes,
The 3 times it was used.
yes.
But he has said, independent of 367,
It can still be done.
the power
Look,
will be-
which is why I come to my next point. And that's one of the 360s. They became the successors. They were certainly the successors. If there was any constituent power which could replace the Constituent Assembly in the proviso, it was certainly only the Legislative Assembly. Now, your Lordship is right. 367 could not be the source for. That did not necessarily have to be the source for that replacement between the Constituent Assembly and the Legislative Assembly. Did not have to be a source. But it was implicit in any event. All 367 did, or the amendment to 367 did, by CO 272, was to recognize an implicit position. It was not only synonymous for a substantial period of time, but it was a successor. And CO 272 did not make a substantive change. It made a change it was a clarificatory change, which was already inherent, which was already implicit in Article 373 proviso.
All right, anything else, Mr. Jethmalani, now?
So now the Damnu's case applies. Please, one look at Damnu to consolidate this argument.
Damnu we have seen, we'll have a look at it.
Just some paragraphs with special emphasis.
Which are the paragraphs? Just give us.
Yes, I'll give a Lordship's the paragraph. Paragraph 25. Oh, no, I put it in my list. Lordship, just gives me a minute. Yes, my lord, the factual situation, which my lord makes the question of law decided clearer is in paragraph 6, 1, 7, and 8.
Of Damnu.
Of Damnu. That's the factual situation. But if your lordships recall, it was that change. It was that change of Sadr Riyasat to the governor of Jammu and Kashmir. And the findings are at 1922, actually 19 to 28. 19 to 28. And though the 367 was upheld by that constitution bench, the amendment to 367 was upheld by the constitution bench on the ground that it was merely a clarificatory. It was not an amendment of substance. So also here, I bring my submission within the four corners of Damnu
All right.
that this was inherent.
Anything else, Mr. Jethmalani?
No, well, I,
Because now the second point you've covered is.
well, and as my learned friend pointed out, that Damnu also refers to it. Damnu says it's sought in aid of its judgment, section 18 of the General Clauses Act.
Yes.
So, my Lord, General Clauses Act applies because it's my contention that the Constituent Assembly is the successor. The Legislative Assembly is the successor, and section 18 of the General Clauses Act will squarely apply, as it does. So the powers vested in the original authority will devolve to the successor authority. In this case, the Constituent Assembly, the Legislative Assembly.
Thank you, Mr.
Well,
Thank you, Mr.